All right. Good afternoon, everyone. We're just going to go ahead and get things rolling here. My name is Hunter Faulkner. I'm a partner here at Jimerson Birr. I focus on commercial and residential real estate transactions. I also practice land use and development law as well. Jimerson Birr, if some of you don't know, is a full-service law firm. We're here essentially located in Jacksonville, Florida. We have reach across the country. With servicing many clients in many different areas. Today is going to be a real estate focused panel, so we thank you for coming. This is our first in-person event since the outset of the pandemic, so we're going to going with a hybrid approach today. We've got people joining us both live and in person, and we also have folks attending online as well. So we thank you all for being here, and we are planning on reserving 10 or 15 minutes at the end of the presentation for question and answers. Should anybody have any questions that come up during the presentation that we don't cover. For those of you attending online, if you'd like to submit a question throughout the presentation, just click on the comment bubble. You can go ahead and type in your question, and we'll get it here, and we will address it at the end of the panel. So there is a packet of information for those of you joining us today in person in front of you. It's going to include the slides that we're going to go through today, as well as some information about Jimerson Birr and those of us on the panel today. And without further ado, I'm going to let my other two colleagues introduce themselves today. So Lynn.
Hi, everyone. My name is Lynn Rohde. I'm an attorney at Jimerson Birr. I practice primarily in the regulatory space, so permitting, licensure, compliance, and I'm going to be mostly focused on that today as part of this panel. And thank you all for joining us, and we're very happy to be able to speak with you today.
I'm Deborah Ruiz, I'm also attorney here at Jimerson Birr. Focus primarily on real estate transactions, but I do other transactional work, basically anything with the contracts. But my first love is real estate, and so we'll be discussing that today.
All right, so today's focus is going to be on commercial real estate transactions and how to avoid common buyers pitfalls. It's a timely presentation because the current real estate market, being as robust and as busy as it is, at least gets buyers and investors and developers very excited about jumping into transactions. Oftentimes this can lead to things being missed when you're trying to get the deal put together that could be more adequately and thoroughly gone through and covered if you engage appropriate real estate counsel. So that's what we're going to go through today. We also are going to address certain things when you're jumping into a real estate transaction. People are also eager to possibly avoid going through a customized contract for that transaction, so they'll fill out a Florida Association of Realtors contract. Those contracts are great, but they often can leave a lot of things out depending on the size and scope of the deal that you're entering into. So we're going to address some of those concerns as well. So we're going to get started today with Deborah. Who's going to talk about letters of intent.
Letter of intent. Many of you may already know what those are, but if not, they are a written summary of the basic key terms of the deal. So you can do them for a real estate purchase and sale agreement, or you can use them for lease agreements. Today, of course, we're going to talk about real estate purchase and sale agreements. Typically, you would see the buyer submit that to the seller, but the seller can actually also propose a letter of intent with its general terms. So it's the starting point for the negotiation. It sets up all of the key essential terms. And of course, we have sort of the basics that are considered in the LOI. So we have the parties, the property, purchase price, earnest money deposit, inspection periods, closing costs, closing date. So it sounds simple enough. We hit all those key terms and we're done with the letter of intent, right? Well, the problem is there are things that are not necessarily addressed just dealing with those terms. And a lot of times a buyer will come to their attorney after they've signed the letter of intent, and it makes it much more difficult to renegotiate the terms that are already in that letter of intent. And so it's always my hope that before that letter of intent is signed, even though it's non-binding, that it can be non-binding, that the buyer actually discuss the proposed terms of the letter of intent with the attorney, so we can go through what other factors need to be considered in that letter of intent. Sometimes you want to have a better description of what the property is. Are we just talking about real estate? Are we talking about land? Is there a building? Is there personal property involved? So we want to get a better scope or idea of what is actually being purchased. Are there warranties to consider? Are there development rights to consider? Are there leases being assigned? Or do we need to terminate a lease? So we want to address some of those considerations in the letter of intent. And then what I especially see right now with the market that's so hot is building in enough time for inspection periods. A lot of times right now we're seeing 30-day inspection periods. And when you're dealing with commercial real estate, that may not, it's probably not enough time right now to get all of the due diligence work that you need to do in that 30-day period. I mean, I've seen surveyors taking possibly 8 weeks right now because there's so much work to be done. And so you're not having that time frame to fit in the 30-day inspections. The other thing that a lot of times buyers don't consider is building in extensions of that inspection period, having that discussed upfront in the letter of intent rather than getting to the end of your inspection period under the contract and then having to ask for an extension then, right? Sellers are looking at, we're going to get this deal done in 30 to 60 days, that's it. But if you address it in the letter of intent, you're prepping the seller for what's realistic, what's going to happen in this time frame, what can be accomplished, and when can we really close. And so I think it's better to address that in the letter of intent ahead of time. And that way, everyone is generally consistent with the terms that are in the LOI and no one is upset about changing what they thought the deal terms were later on. Then also the other thing that I like to address in the letter of intent is conditions precedent. What do you need to actually close on this purchase? Do you need financing? So do you want to have the ability to get out of the contract if you can't obtain a loan? Are there environmental concerns that need to be addressed? Is there wetlands that are on the property that need to be considered as part of the investigation of it? Are there zoning and land use issues? Do you need a change of zoning? Want to build in that time period, and so you need to address those kind of conditions in the LOI itself. And then also finally, assignability. Sometimes buyers will come and they actually have a company that they already have established and it's going to be the actual buyer. A lot of times they'll think about it later and they want to have the ability to assign it, let's say, to an LLC that they create. It's always good to have that addressed in the LOI because a lot of times the seller will restrict the assignability of the purchase and sale agreement. We're going to go through these in a lot more detail. I believe Lynn's next. She's going to kind of discuss those pre-purchase considerations that will help build into the LOI.
Thanks, Deborah. So everyone knows the real estate market's hot. What everyone probably also has seen in some capacity, if you're in this field, is the tendency to shortchange things that are oftentimes prophylactic, things that are considerations that can arguably be dealt with later. But the point of this conversation is to emphasize how much easier and how important it is to try to address as much as you can upfront, particularly in a hot market, particularly when everyone is pushing you as real estate, financial development professionals to get things done quickly. So Deborah talked a little bit about the terms of an LOI. I'm going to walk through some pre-purchase regulatory considerations that are important to keep in mind from day one. A lot of what we're going to talk about is addressed in the LOI, but a lot of it also is sort of tackled as you go through the diligence process. What's important to keep in mind is to have a plan to address it at some point before you get to 2 days before closing. So the first bucket is land use zoning. And as we deal with changing demographics, as we deal with accelerated growth, land use and zoning becomes even more important. Localities are dealing with, in an unprecedented way, growth, particularly in raw land areas, as well as demand for brownfields and urban redevelopment. And with that comes policy considerations, political considerations, pressure on planning and zoning departments. And that pressure can be a great opportunity. It can mean that there is future land use possibilities that were not there before. It also can mean, though, some pretty significant delays, pretty significant hurdles and considerations that really a purchaser of land needs to be sure they're aware of going into any sort of deal, particularly those involving development of any kind. Generally speaking, a couple things I'd like to point out. In a hot market, comprehensive plans of the locality become more important. Is the locality keeping up with their comprehensive plan? If not, there are likely to be some changes to the extent there can be. Know what future land use is for the parcel you're interested in. Know what future land use is for the surrounding areas. Know what the trigger points are. Know what the political pressure points are associated with those future land uses. Pay attention. It's important. There's a ton of information out there. It can be very voluminous and hard to sift through. We can help with that, but it's important to pay attention to comprehensive planning. Amenities, infrastructure, all of those needs are increasing right now for every locality, particularly in this area, particularly in Northeast Florida, South Florida as well. Huge development pressures, very important. Utilities, access to utilities, all of that needs to be taken into account and should be part of your pre-purchase diligence planning. Going into the LOI to the extent you can, and then subsequently during the diligence period, depending on what information's out there when. Another thing that is important to pay attention to, overlay districts, PRDs, community development districts, all these really can impact development plans on a particular parcel and what funding mechanisms are available for those. And all of that is really important in terms of a buyer's purchase price, in terms of a buyer's opportunities. Pay attention to CDDs. Pay attention to PRDs in particular right now. Pay attention to overlay districts, grants. We'll get into that a little more later. These are really essential, again, particularly in boundary areas, areas that are changing in terms of their use and development. Riparian rights becoming more and more of an issue. Localities generally punt on riparian rights, right? They have building departments who look at permitting for use of shoreline, whatever that use may be. They generally don't determine who owns what. They generally don't clearly define who owns what. If that might be an issue for something that your client is trying to do or that you're trying to do, you really need to get a handle on riparian rights associated with those parcels you're interested in. All right, the next bucket, in terms of pre-purchase regulatory considerations, I've lumped environmental and geotech in. There's, in my mind, a sort of triangle of regulatory due diligence in the environmental space. The first, broadly speaking, is the wetlands bucket. Most areas in Florida, you really have to pay attention to wetlands, and wetlands and streams. A lot of people forget about streams. Streams are in there too. Don't forget about streams. Wetlands and streams can make or break a project. It can have a tremendous impact on the value of a piece of property, not just raw land either. Land that has been developed has a history. It also can have links to navigable waters, right? Doesn't mean because something's in the city that you're not going to have to worry about environmental issues. Even wetlands, there can be little tiny patches of wetlands that in certain cases you have to pay attention to. So wetlands, a wetlands assessment, if you don't already have information available, is very, very important in my mind. I'll note that in late 2020, EPA delegated Section 404 Clean Water Act dredge and fill permitting to the DEP. This is a pretty significant change. If you have a client or if you are interested in anything that might require any development that might require dredge and fill permitting, know that there are going to be pretty significant procedural and operational changes that are already underway. This has already happened. There are some legal challenges, but assuming they don't prevail, DEP from here on out is going to be your primary permitting agency for 404. Ultimately, I think that might streamline things for developers, but right now there are some growing pains, and DEP is, I think it's fair to say, unprepared. I think we've seen that with some of our clients already, to take on this responsibility. So make a note. Second part of the triangle is the environmental site assessment, the phase 1, as we call it. Pretty much, I'm biased as regulatory attorney, pretty much essential to just about every transaction. I would be hard pressed to note a transaction that's not a simple single family home purchase that shouldn't have a phase 1 done, both if you're the buyer. Phase 1 is currently operating under the standard 15E 152713, which has been in place for quite a while now. It's dates back to 2013. That is very soon to be updated. We were expecting it to be updated in January of this year, because the current standard does sunset on December 31st of this year. We have not yet seen that new standard, but pay attention. It will have some pretty significant changes, including things like new definitions of CRECs, or controlled recognized environmental conditions, additional history requirements that an environmental professional will have to take into account in the report. So your phase 1 reports are going to look a little bit different once we get that new standard, but very important to get done. The third part of the triangle is endangered, threatened, protected species studies. So generally when I engage on behalf of a client, an environmental professional, I, as standard procedure, ask for these 3 studies: wetlands, phase 1, endangered, threatened species. In this area, you're looking at a lot of concerns with things like the scrub blue jay, the gopher tortoise, various protected and endangered plants, eagle's nests tend to be important. These are all things that can really impact development plans and redevelopment plans for a parcel, and really should be looked at during the diligence period. And if possible, if you know there might be some issues, planned for with the LOI, right? You can build in, as Deborah mentioned, contingencies, and they can include these sort of things, and they should, if there's an indication they're going to be an issue. Geotech. So geotech is very important in areas that have karst topography, subsidence issues, fill from former projects. It can be incredibly expensive mistake to not take into account geotech considerations, particularly for certain types of development projects. So pay attention to geotech. I almost always add that on to sort of my standard diligence considerations. And again, you can build those considerations into an LOI. Don't have to wait for your diligence period. I'll note if your parcel you're interested in is in the coastal area, there are going to be additional considerations. So pay attention. Coastal areas have their own set of opportunities and considerations. Finally, on this slide, well, a couple things. Note that there's overlapping jurisdiction. So when you're trying to gauge your time difficulty for potential permitting for development, be sure you not only pay attention to state regs, but there's local, there's water management districts, and in some cases still there's federal. So don't forget that even though you think you're checking the box on an issue, that issue might actually be looked at, regulated, and have requirements from 3 or 4 different agencies. So please pay attention to that. Sometimes I see clients who go in and say, well, I got my sign off from the locality. You know, I know that this parcel doesn't have a problem with stormwater issues because it was addressed by the prior developer. Well, did you check the Water Management District records? Did you check with DEP? Did you check with Corps of Engineers? Yeah, all of that is important. And finally, wetland and stream credits right now are very expensive. They're maybe not an all-time high, but they're quite high in certain areas in Florida. So pay attention if you do have wetlands that you're going to need to mitigate for. Take a look, ask your environmental professional, ask your attorney to look at what the market is right now in case you need to purchase credits. Deborah mentioned the survey. Is that slide? Current? Oh, okay. It's funny on our screen. Sorry, Deborah mentioned surveying right now. Just note, surveys are way backed up in certain areas. Central Florida, 6 to 8 weeks.
Yeah.
Pay attention to that, build it into your diligence considerations. Incentives to keep in mind. I won't spend a lot of time here, but also when you're trying to plan out your possibilities, your opportunities, as well as potentially some costs, pay attention to what incentives might be there. We talked a little bit about CDDs, local grant programs for infrastructure, et cetera. There's also conservation easement opportunities potentially. There's green space programs, there's brownfields. The brownfields program can be very, very lucrative in certain cases. So pay attention to all of that. It's important, and it can and should be built in again early into your calculations. All right. Finally, I wanted to talk a little bit equally important to, and sort of as an umbrella consideration to your regulatory considerations, is the corporate structure of the entity that's making the purchase. So we're talking right now about common buyer pitfalls. Well, buyer pitfalls can be much worse for a buyer if that buyer does not take into account risk protection, right? If your buyer is a limited liability corporation, for example, LLC, there are built-in liability and risk protections that make all of what we're talking about in many cases more palatable, more doable, and really should be considered before you enter into a contract. Your buyer entity is very important. You do not want to put, unless you've made a calculated decision to do so, an individual's name on a purchase contract. Because then that individual is the entity that's exposed to any risk associated with that purchase. Instead, set up an LLC. It's not always the right vehicle, but often it is. And we can talk about what is the right vehicle. In certain cases, you have S corporations. In certain cases, it makes sense to do multi-member LLCs. In certain cases, it makes sense to do single-member, manager managed. All of this provides tax considerations and potential advantages and regulatory and other risk protections. So look at what entity makes the most sense to buy a piece of property. Generally speaking, if you or your client have multiple different parcels that they're invested in, you're going to want separate entities owning, purchasing those parcels. Not always, but oftentimes it's a great way to limit and redistribute your risk. Have different entities going in, know what the benefits are of the structure that you choose to make that purchase, and know it really early on from the outset. That should be the entity that goes in your LOI. It should not be Mr. Jones. It should be, Florida LLC. I think that's all I had in terms of pre-purchase, and I'll look forward to your questions on the back end of the presentation and turn it over to Hunter.
Thank you very much, Lynn. So now we're going to get into a little bit more of the contract drafting, and Deborah and I are going to cover some issues that we see and protections again that you're going to want to build in when you're taking that LOI and converting it over to a purchase and sale agreement. So, the first thing we're going to discuss is title and survey language. And this is something that I'd like to go back to the form documents that you can get from NEFAR, FAR. While these documents do have very standard language with regard to title and survey requirements, it's very limited. And so it's oftentimes it's incumbent upon you as the buyer to build in, first of all, the appropriate time to examine the title commitment, to have your new survey completed, and examined thoroughly so that you can file those appropriate title and survey objections with the seller of the property. And at the same time, you want to build into your contract those title requirements that the seller is required to cure. So as for those of you that are familiar with title commitments, it's going to come with all the Schedule B1 requirements. Those should all be required to be cured by the seller, as well as any liens or assessments that are on the property, any overdue taxes. These are all items that need to be cleared up in advance of closing or simultaneously with the net proceeds from closing, so that you can take clear marketable title. We also want to make sure that your B2 exceptions are fully examined along with the survey, so that you can make sure that everything is appropriately reflected on the survey. You can see how any of those easements do encroach into the property and whether or not they're going to affect your ability to improve that property with your intended improvements. So I always want to make sure that I have appropriate time built in for that. And then reserving language within the same section to build in how they're going to cure any title objections that may arise after the effective date of the contract. So oftentimes, either new assessments can pop up, new liens can pop up, any issues that may impact the marketability of the title to the property that you're purchasing. They need to be cleared in the same manner as those initial title and survey objections that you're making. And so you want to make that a requirement on the seller. And at the same time, as always, you want to build in those contingencies with regard to whether or not the seller chooses to cure those title objections as you go forward with. So if the seller is refusing to, then at that time you want to have the ability to say, okay, well, I'm done with this transaction if you're not going to give me the clear title that I'm looking for, and you build that in so you get your deposit back and walk away from the transaction. No harm, no foul. But at the end of the day, your title marketability is going to very much impact what you can and cannot do with the property, including whether or not you want to get additional financing for the property to move forward with your intended improvements. So we always make sure that that is one of the provisions in the contract that we pay very special attention to throughout the drafting process. Next, Deborah, if you want to talk more about more broad topic, but due diligence and inspection periods.
Well, first of all, I kind of like to tie in the title and survey objection period to the due diligence period. A lot of times you'll see sort of in the standard form contracts where they're running independently those timeframes, or it's much more limited time frame when you're looking at the title and survey, right? So if you tie them together for the due diligence period, you have an expanded time period usually to then consider the title and survey matters. And that is part of your due diligence work. So during your due diligence period, basically uncovering every stone that you can find. So what's all the details about the property. You want to know everything you can about the property, and you have hopefully a good amount of time to actually complete that in. But so I like to take that title and survey review period and tie it together with the due diligence, because those items that are exceptions to your title, let's say there's a parking easement, there's restrictions, those are going to affect your use of the property, and it goes into your consideration of how you're going to use the property, your due diligence inspections. So the first thing is when I'm looking at the LOI, I like to put in that time period where they match up. And like I said before with the LOI, I want to make sure either I have that initial inspection period built in with an extension option to continue looking at the property if we need to. I like to have that built into the LOI. So that way the seller is not surprised or frustrated later on when we need an extra 30 days to address some of these considerations. So from the LOI, we would build it then into the contract. Additionally, you want to consider, okay, when does the deposit go hard, right? Do you get a free 30-day extension of your inspection period, or do you have to put up additional deposit money, right? Do you have a way to still get back all of that deposit money if you terminate at the end of that additional extension period? So these are all considerations that you want to address at the LOI point, not afterward. You've signed the LOI and then you start drafting a contract and we start talking and I say, look, surveys are taking 8 weeks sometimes, or, you know, environmental phase 1, we can't get it done in the 30 days. We should have asked for additional time period. Your best negotiations are at the LOI stage to build that in then. So once we get to the contract, we're drafting all of those provisions from the LOI. So every property is unique and you have to consider all of the different ramifications of what's affecting that property and your use of the property. And so it's key to get all of your professionals involved, I think from a beginning standpoint, especially, you know, if we're trying to do this in 30 days, that's a very short time period. So you need to have all of those professionals, I think, lined up ahead of time, ready to go. And you want to be able to have sort of that network to discuss it with your engineer, with the attorney, environmental professionals, because there are things that can be missed. I mean, we had one recently where the engineer did not consider the parking requirements. What did the town require for minimum parking for the new use that the structure was going to be used for? I mentioned, do we have sufficient parking? 2 days before the inspection period, engineer had not, all along, engineer saying, yes, everything is suitable for their expected use of the property. They did not address parking. So there we are, scrambling. Thankfully, we have, you know, sufficient extension periods to address with the seller. That worked out fine. But that's why it's always beneficial to actually work together as a team. You have checklists, you can have all those considerations between the attorney, and all your professionals and the buyer. What do they want to do with the property? What do they need to know about the property? Are we looking at raw land? Are we having to look at environmental considerations for that? And like Lynn said, you need to do a phase 1. Without a doubt, there's no reason why you should be relying on an old phase 1 or not doing a phase 1. It's unacceptable risk right there for you. So a buyer should always get that phase 1 and make sure there's time frame built in for that. And any other environmental considerations. So you want to make sure that that's addressed in the due diligence period. You know, when we talk about the time period, you have to think about what can you realistically accomplish in 30 days if you don't have this set up. That's why you really want to try and, if you can, you get an existing survey ahead of time before, so that way you kind of know what you're looking at the property. Hopefully you can go back to that surveyor and maybe they can get you a new survey faster than going to a different surveyor. So these are things to consider, and the timing and what information you can gather, even at your initial look at the property and making the LOI. And then you have to look at all of the different inspections that you do based on each property. Like I said, if it's raw land, it's site suitability, zoning, access, development rights. I mean, there's a lot going in when you're just looking at raw land. But even if you have an existing structure, improved property, in that case, we were looking at an existing structure. They were going to use it for a totally different purpose. It was actually it was actually used as a prior like college building, right? And they were going to turn it into a medical use. So you have to look at, okay, do we meet all of the same zoning requirements? Like I said, do you have to look at the structure itself? You have to look at the mechanical issues. So all those inspections get done during the inspection period. If you're looking at leased property, you want to get the tenant rent rolls, you want to review every single lease. You want to talk to the tenants if you can during that time period. Understand why they're still there. Why are tenants leaving? If you think, oh, they're just not operating the premises in the best way, and you're going to be able to turn around and improve it and get higher tenants in there, then you really need to talk to the tenants and find out what's going on. You need a hands-on approach with your inspections of the property. And so, all of these different types of property have different considerations, but basically the goal is to leave no stone unturned during that due diligence period. Find out all the information you can, because that's your chance before you lose your money, before you're buying property that you can't use. And so, I mean, the end goal is you want property and you want to turn around and use it for what your intended purpose is. And for example, if you can't put, medical office building in that, on that property and use it for that purpose, you're stuck with this. You got to try and sell it, and you've bought property that doesn't meet your needs for that. So those are always, important to consider during the due diligence period. Sometimes, like I said, you look at some of the zoning issues and whatnot, and you'll consider that during the due diligence period well, and Hunter's gonna kind of go through those in a little more detail.
Thanks, Deborah. So with regard to seeking entitlements, it kind of circles back to a common theme that the three of us have mentioned with regard to what is the intended use of the property. It's always the first conversation I have with my clients is saying, okay, you want to buy this, what do you want to do with it? Because that's where the research really starts. Do you have the appropriate zoning, the appropriate land use? What other entitlements are you going to have to seek? How long is it going to take to get those certain entitlements? When you're right now, Lynn mentioned dealing with DEP taking over permitting process from the Army Corps of Engineers. Well, they're behind the 8 ball on that pretty significantly right now. So you need to know that going into it. So oftentimes if I have a buyer that's coming to me and they want to set up a contract and they know that they need a land use change or a zoning change, then I'm looking to build in as much time in that contract to get that. Usually, no less than 10 months, and that's being, very tight with it. I usually want to build in at least 12 months plus extensions to get those required land use and zoning changes and other entitlements. And that's just cost of doing business right now with your different municipalities here in Duval County. I do a lot of work in St. Johns County, which can also be very slow, and it just comes with the territory. So you want to build in those timelines appropriately. The extensions are always almost always used in my experience. And then you also want to make sure that the contract are conditioned on receiving these entitlements. Again, and these need to be final, non-appealable entitlements. So after you have that final public hearing with whatever, Board of County Commissioners or City Council or whoever, you want to make sure that 30-day period elapses after the receipt of your permit, and then you are no longer subject to any appeals from any public opposition. So always build that in. And then I'd like to mention briefly public opposition as its own subcategory. And Lynn talked about, political considerations and whatnot. Well, if you're moving forward with a piece of property that's completely surrounded, maybe it's a commercial piece that's surrounded by a lot of residential area, and you're going to change the use in it of that piece of property, or you're going to go in there and you need some entitlements from the municipality to develop a new project. No matter what, you're always going to encounter public opposition. And maybe people just come in and don't want anything built on a piece of property that's been vacant and been quiet for a long time, just because they don't want to disturb, their everyday habit of coming home and not having to deal with lights or new structure or construction or whatever. It's always important to, in my experience, to do a little public relations with the neighborhood. Maybe, try to schedule meetings, post signs, say, hey, we're meeting at this place to address this. I've done this for my clients in a lot of cases, especially in St. Johns County, where you encounter a lot of public opposition. But this just helps soften the blow, because at the end of the day, your final approval likely comes from elected officials, and elected officials are often influenced heavily by people who are opposing or supporting your project. So it's always good to get ahead of that if you can during that time where you're going to, you're submitting all the proper engineering and environmental materials to get your permits, and you're complying with all the land use code regulations. You always want to button up that public opposition side as well. So next, Deborah's going to touch on conditions precedent.
So Hunter kind of touched on this a little bit. Sometimes you deal with zoning requirements, entitlements in the inspection period. But ideally, you deal with it in 2 sections of the contract. You want to have a sufficient time period in your inspection period to start looking at them and address them, but also you want it as part of a condition precedent in your contract. And so the condition precedent is what allows you to terminate the contract if you don't get that zoning or land use change, for example, if you don't obtain financing. typical one we see, of course, is financing, right? So if you're not going to get the loan, then you need to be able to terminate the contract because you don't have the cash to purchase the property, right? So we see those even in residential, but that's also a consideration in the commercial real estate transactions. But you want to address all of those items that are absolutely necessary for you to purchase this property and have them as a condition precedent. So that way you can still terminate the agreement, still get your deposit back and not be at risk of losing your deposit or having to close. These are what allow you to, like I said, stop the contract from going forward and requiring you to close on the deal. So you always want to build those in, make sure there's the sufficient time, like Hunter mentioned, when we're dealing with those kind of issues, and making sure that you've included all of the contingencies. So if you have financing, if you have zoning and land use issues, if there are environmental considerations, do you have wetlands mitigation issues that need to be addressed? You want to put those in as part of your contingencies in the contract. You want to address those in the LOI in the very beginning. And I think Hunter's going to talk about default, which, you know, if you don't have these conditions precedent, then you're liable, you're obligated to close on the purchase, and you can be at default if you don't. And so he's going to go through some of those issues as well.
Right, thank you. Yeah, the last section that we're going to discuss today is default, and the language that you're going to want to build in with regard to, you know, for any buyer that is walking into a contract, like Deborah said, if the conditions precedent are met, or if you allow timelines to expire and then you're trying to get out of the deal, you know, you want to limit your exposure simply to that money that you have in escrow. Buyers should always write it in that that is going to be the assumption of your liquidated damages is the money that you're setting aside in escrow. You do not want to allow the seller's attorney to build in their right to claim further damages or anything else aside from that money that you already have at risk. However, sellers, especially in a market like this, if you're going to tie up a piece of property and you're going to go through a long due diligence process, get land use changes and other entitlements, over time, that property is likely going to appreciate. So sometimes sellers may think it's advantageous to try to get out of the deal that they've agreed to close on because they think they can get a higher price from a new buyer now that we're, you know, 8 months or a year down the road. So you want to make sure that you reserve first and foremost your right to specific performance as a default condition should seller default on its obligation. I've noticed, and I don't know where this trend has come from, but I've noticed that in some form contracts that the specific performance provision has just been struck through. And when I ask why it was struck through, the only answer that I'm getting is that, oh, that's common practice. That's not common practice in the transactions that I'm typically involved in. I think that if you're too eager to get into a deal because you think it's too good to pass up, you're really sacrificing a lot of rights right there if you allow the seller to eliminate that as one of your rights should the seller default. So if however specific performance is not available, so maybe the seller sells a property out from under you and you're not able to file lis pendens in time, then you want to reserve your right to claim additional damages, additional monetary damages, as well as the ability for you to claim back those damages that you spend in your project costs and your pursuit costs. So you're hiring engineers and environmental specialists, geotech guys, surveyors. A lot of these costs can add up. And land use attorneys to get your entitlements, you're looking sometimes up to $100,000 in costs. If the property's sold out from underneath you, you want to build in your ability to say, hey, well, you might have sold the property out from under me, but not only am I going to get my deposit back, you're going to owe me for my pursuit costs. I always like to put that in there, especially if it is a contract that you are going to spend significant money in your due diligence period. But with that, it looks like we are running up on the end of our hour. As I stated before, we are reserving about 10 minutes for any questions that you guys may have here in the live audience or online. So
We'll start with the room.
yeah, I'll open up floor. Any questions here?
Is there you mentioned the difference between sole member LLC versus multi-member LLC, when that's advantageous or not? Is there an example you can give as to when one would be advantageous versus another?
Sure, so there's there's typically two primary considerations when you're looking at either single member or multi-member LLC, and one is your tax bucket. And typically, I like to make sure an accountant is involved with that consideration, but there are tax advantages to single member LLCs. There also can be, though, some pitfalls depending on what you're trying to accomplish, what your financing is, et cetera. So tax is one bucket. And then the other side is from a liability standpoint. There, generally speaking, are more there's more risk protection in a multi-member LLC than in a single member LLC. And for example, a creditor has significantly more hurdles to go after a multi-member LLC than a single member, obviously because there's the rights of more than one party involved. So a lot of times we'll look at, even if it's a single entity, a single person trying to purchase, maybe bringing in a 1% owner of an LLC to make it multi-member, to bring in some more creditor protections there. There also can be some liability protections in terms of the regulatory space, also just general civil liability. Again, multi-party means that no one party can be targeted solely. So oftentimes, and not always, it's a huge generalization, but often we'll look at a manager managed multi-member LLC for the most liability protections you can get for the purchase of real property. Again, it's very case specific, but if I had to generalize, that's usually, the most protective entity structure you can use.
Great, thank you.
Mm-hmm.
All right, we got one from our virtual audience. Someone asked, should environmental diligence be done on raw land? Do you want to take that?
Sure, I can jump in on that. Generally, the answer is a resounding yes. So raw land, first of all, can mean a lot of different things. And the history of a parcel that looks absolutely pristine and never touched can indicate otherwise. So that's the first thing. Secondly, raw land that, and this ties into the history, but raw land, for example, could maybe never had any structure on it, but it was used for agricultural purposes. Just for example, citrus. Let's take a citrus grove. Citrus groves tend to have a lot of metals in the soil. They can also have pesticide residue. They can also have all these other considerations we're talking about, wetlands, streams, potentially some geotech considerations. So when you say environmental diligence, I'm assuming the whole bucket, and the answer is generally yes. Endangered, threatened species, wetlands, streams, potential geotech issues, all of that can be present on raw land. And a phase one is very important to get to the bottom of what the history of that property actually is.
I think we have time for one more. Does anyone else in the room have anything they wanted to ask before? Okay. Let's see. The last one will be, is it okay to use a seller's existing survey, or do you recommend having a new survey done?
Yeah, I always default to a new survey. I mean, it's sometimes, again, people are looking to maybe save some money, but a seller's existing survey, you don't have any guarantees, one, that how new that survey is, whether or not it's accurate, whether or not it's something that your lender is going to be able to rely on if you're seeking financing for the property. And plus, going back to what I was talking about in the title and survey section, I always like to have my B2 exceptions added to the survey that my clients haven't done. It just gives you a much more accurate, real live visual representation of the property so that you are fully informed about the property prior to going through your, the expiration of your due diligence period, your title and survey objection periods, and closing.
Right. You want to know where those easements are on the property. Do they actually touch it? Do they benefit it? So you wanted to get that new survey done. It's always good to get the prior survey as part of the due diligence materials that the seller provides, because that gives you that background info. If you can get that before you sign the LOI, that's always advantageous, because you get a good idea, at least basic beginning understanding of what does the property look like, what potential issues are there that we may need to address in the contract or later on, so.
And I'll just piggyback real quick. I get the question a lot, can we rely on an old phase one? And no, you can't. While it might give you some useful information and may be helpful to the environmental professional going forward with a new phase one of the biggest reasons for getting a phase one done is so that you can meet the requirements for all appropriate inquiry as a purchaser. And all appropriate inquiry is what gives you insulation from potential circle liability down the line, and even some civil liability. So you want to be sure that you have a current phase one so that you can hold it up and say, I went through as a buyer, all appropriate inquiry, and I have a current phase one, so that down the line, if it's discovered there's environmental contaminant coming off of that property, you have some liability protections, statutory liability protections.
I think that will conclude the end of our Q&A. If you guys have anything you want to add before we close?
Thank you so much for coming today. Those of you guys who joined us in person and online, we really appreciate it. We hope it was informative.